All right. Welcome to Bad Law, Worst Facts. I'm your host, Michael Takla. Today I got on here Tom Bosworth. He just got a pretty big verdict here. And it was in Pennsylvania, right?
Yeah, it was in Philadelphia County. Yep.
Okay. And I hear about big verdicts in Texas where I'm from all the time, but to hear a medical malpractice verdict like this with the facts that I heard, I thought it was crazy. But tell our viewers a little bit about the facts.
Yes, so this was a case involving a woman in her 50s who had been going to her primary care doctor for like 4 years with repeated complaints of back pain and, um, you know, numbness and tingling in her feet and her legs. And it kind of got worse and worse over time. And the doctor never ordered any image of her back, no MRI, no CAT scan,
Yeah.
no X-ray, no referral to a specialist. She ended up having, unfortunately, a very damaging mass in her spine called a AVM, which is just it's arteriovenous malformation, but it's a
Yeah.
cluster of blood vessels that, left untreated for years, cuts off blood supply and oxygen to your spinal cord, and you end
Yeah.
up paralyzed or close to it.
So we're gonna get into this case, but you're you're young. You're 33, 34 now, but you're 33 at the time of the verdict.
Yeah, I don't feel young, but I am 34.
That's the practice of law.
Exactly.
Uh, so it turned to me the other day. He's like, "You got a lot of grades." I'm like, "I mean, what do you expect?" Um,
I also have two little kids too, so that helps too.
oh, that'll do it. Yeah, I'll do it. You're just never sleeping and never sitting still. Well, I'm glad you can sit still for this. Um, and this is you are is I saw some statistic that you're like the youngest attorney to get a eight-figure verdict in Pennsylvania. Is that right? Or,
Yeah, so I at least as far as I can tell, the youngest lawyer to get a eight-figure verdict for a living plaintiff in
yeah.
a trial, in a civil trial. And a guy I know here in Philly had a death case, and I think he got a $20 million verdict. So he inched me out by about 400 grand. But I distinguished that by saying the living plaintiff. So, but
That's
yeah,
fair.
it was it was definitely I think it was the biggest that year in Pennsylvania for med mal.
I mean, yeah, and I'll tell you in Texas, MedMal is I don't want to say it's dead, but it's puttering away. I mean, you've got to be very, very particular about it. Here at our firm, we used to do a little bit of it, and then we just realized it's so expensive to keep a docket like that, and you've got to be so liquid that it's tough, right? Um, but and you've got to be I mean, you've got to be tenacious on the cases because, and you telling me this, just a brief overview of the case where it's a failure to diagnose. I am actually personally, I'm a little terrified of those cases, right? Because you've got to have a really good set of facts that a jury's just going to be like, this guy really did not care about her. Um, and so, tell me a little bit about, the story. I mean, like, was it just she would come year after year or something like that and completely consistently complain of this? And he was just like, nah, it's fine. You're work at a desk or something. That's what it's coming from.
It definitely wasn't a slam dunk. So uh, you look at the verdict number and you might think that, but the reality is that the case came down to about 10 visits total that she went to this doctor from 2012 through 2017.
Yeah.
And she's not going every time saying, geez, my back hurts so bad. Some visits are got pink eye, right?
Okay.
And but you see a pattern consistently over those visits where back pain's coming up over and over again. Numbness in her feet and legs was coming up over and again.
Right.
So I think part of my job in the case was to help the jury understand. Look, you and I don't know this stuff, at all, but to a doctor, this is spinal cord 101, red flag.
Right.
Hello, we need to figure this out, make sure it's not something catastrophic, and the doctor never did that.
Now, uh, you've got to tell me, where was she working at the time?
So she actually worked for the same health system that was the defendant in the case that we sued. and she had been um, fired from her job, terminated because of her disability due to the
Yeah.
spinal cord injury.
So
Uh,
when at what point in time did she actually get like treated, and what ended up happening to her?
yeah, so she was formally diagnosed in about February 2017, and then she
Okay.
underwent surgery to try to reverse some of the damage. Unfortunately, it had been too long for there to be any recovery for her after the surgery, but she really couldn't go back to work after that. And I think it was later that same year in 2017 she got the formal termination letter. Give hand in your card, hand in your keys, have a nice life, that type of thing.
Okay. And let's talk a little bit about the extras. We're talking about it a little bit off air. That's why, for the viewers who are watching it, I'm like smiling because I was just so shocked by this. So, um, her, at any point in time, like is she going within her own like company's like doctors?
Well, yeah, that was one of the you know funniest things about the case was that she had been evaluated by these preeminent physicians at
Right.
Penn Medicine, which is the case. It's public. I can say that it's one of the most
Yeah.
preeminent, prestigious health systems. And neurosurgeons and neurologists are evaluating her before the lawsuit, saying she's disabled. She
Right.
can't do any work. She can't work at all. She's got a incomplete spinal cord injury. This is like serious. I mean, and she did have like bowel issues, bladder problems. She couldn't control going to the bathroom. She had a really serious injury.
Right. Yeah.
But lo and behold, the defense came into the courtroom with a bunch of hired experts who had written reports left and right, essentially saying she's really not disabled. She can do all these jobs, and I just it was one of those moments where you're like, are you really handing this to me on a silver platter right now? Are you really going to go there? But they couldn't help themselves, so that was fun to point out to the jury just the absurd contradiction there.
Yeah, I mean that's pretty bad. So I mean, how did you point that out? So like, how did you set that up? Did you set that up in evidence to kind of point it up that way, or did you bring that up in opening? What at what point in time were you like, let me drop this and be like, what are you guys thinking?
Well, so that's an interesting point. So they didn't file a motion in limine to keep any of that evidence out, which I thought was surprising because I thought it was some of the worst evidence in the case for them. So
Yeah,
I got up an opening, and I forget exactly what I said, but something along the lines of, um, folks, if you're wondering whether Miss Melendez here is really disabled, uh, you don't have to look any further than Penn's own doctors, because one after one, they'll tell you she was disabled. Why? She worked there. They fired her. Why did they fire her? Because she couldn't do her job anymore. So I hope, and I said this because you never know what witnesses they're going to call or not call,
right.
but I put it in,
Yeah.
I wanted to put it in the jury's mind. So I said, geez, I hope we don't hear from anybody on the other side that says any different. So I kind of hung it out there, dangled it out there for them to do what they wanted with it. And they just didn't touch it in their opening. But then throughout the trial, it sort of percolated.
Okay. So did you call any of her providers that stated that she's disabled?
I didn't call them because I hadn't deposed them and I wasn't sure what they would
What they
say.
say? Yeah.
And they were going to be represented by these same lawyers, so God only knows what they would blurt out. But what I did do is I brought in a lot of those records through my own
Expert.
experts over and over and over. And every time I would blow it up on the screen and it would say, paralyzed, disabled. And, the doctor has to sign it, Dr. Schuster. And I'd say, by the way, where does he work again? And Penn. And so that was going on for like 7 days straight. The jury's just hearing this. So I think by the time I rested, it was like, I think they just wanted to be as far away from that as they could. They didn't want to touch it, but it had already been pointed out to them. I think the unspoken elephant in the room was, why are you, and this is something that's interesting about trials, is like nobody said this, but I think the elephant in the room was, why are you all on the defense? Why are you putting her through this? Why are we
Right.
here right now? Why are we trying this? Why are we at a trial? Like, why aren't
Yeah.
people aren't stupid. They know there's settlements and people settle out of court. So I
Right.
think maybe that was in their head.
It's like, what are we doing here? Right. I mean, your own facility of the top people in the world are saying, hey, she's disabled, so much so that you had to go somewhere else and pay someone who I'm probably sure has been a testifying expert before, to say otherwise. I don't know. If I was on a jury, I'd be like, well, like, you guys are paying for my parking, right? Like, I need to go.
Well, you know what's funny is they ended up not even calling any of those damages experts in their case. But I still got to point out the contradiction in my case in chief
Yeah.
because the defense lawyers refused to tell the judge. Well, they kept objecting to me getting into it and saying it's not relevant. It's not relevant what our doctor said about her disability. I said, Judge, they have
It's highly relevant. Yeah.
three experts that they paid money to come in and say she's not disabled, and their own doctors say she is. So unless they're going to stipulate right here and now to her disability, I don't. I'm going to get into it because I don't know like what they're going to say,
Right.
and they wouldn't commit to anything.
Of course
So
not.
that the judge said basically, well, look, defense, if you're not going to stipulate to her disability, I think it goes to damages, goes to credibility.
Yeah.
Um, and then so they just kind of shot themselves in the foot, both feet, because they like wouldn't like make a decision about it throughout my case, so it let me drum it all up, and then they didn't call anybody in their case, so it was sort of not a great maneuver, I don't think.
Um, what was their defense then?
The defense was that this thing in her back, the AVM, is really, really, really rare, and um, her symptoms were sporadic and didn't warrant any testing. And even if we had tested, the it wouldn't have been visible on any MRI or CAT scan because it didn't actually exist until they said something like 6 months or something before her diagnosis. So
The only way you would
they
determine that
kind
is
of
if you
just
were to have
made
imaging
that up,
before,
but
right?
that was the defense.
I was going to say they would only notice that if
Exactly.
they had that.
And
Yeah. Yeah.
and they hire. I mean, one of the difficulties I think was the fact that they brought in as a defense expert like the chair of neurosurgery at Yale. So this guy was, top notch neurosurgeon, you know,
Yeah.
best institution in the world, and basically he was the one offering these opinions that you wouldn't have seen this thing if even if they imaged her back when the plaintiff lawyer says you wouldn't have seen this thing. This thing cropped up for the first time 6 months before the diagnosis. All the symptoms she's having back then is just routine back pain, and everybody and their grandmom has that. But so I
Okay.
really struggled. I was reading his expert report, and I'm like, geez, I can't go toe to toe with this guy necessarily on like neurosurgery. He's going to beat me up. He's a chair at Yale. But what I noticed in his report was what wasn't in the report.
Yeah.
So, a lot of what wasn't in the report were these notes from providers throughout the time period that were damning for the defense. Notes that
Yeah.
reflected she was having trouble walking, that she had neurological abnormalities, that she had back pain, gait problems. And so my cross of him essentially was, his name was Dr. Dickey. Uh,
All right.
Dr. Dickey. I said, Doctor, uh, you know, he like buried himself on direct because he started saying, oh well, it wasn't that bad. Her symptoms weren't that bad, but boy, if she had had a gait disturbance, then I really would have been worried if you'd seen like a gait disturbance or oh well, this back pain on this date wasn't abnormal, but geez, if you had seen numbness, then you and I had those notes. There
Right.
were notes that said she had a gait disturbance. There were notes that said so. I was just ran through every one of those notes with him on cross, and then after each one, I would say, "And doctor, that note didn't make it into your report, did it?"
Oh
Over and
no.
over and over and over and over and over and over. So the end of the testimony was kind of like, okay, this guy's just like he said what he told us what he wanted us to hear, but he hid from us the truth.
No, I think what happened is he got called by defense counsel the day before. He's like, "Hey, where's my report?" And he said, Uh, yeah. Sorry, I've been too busy doing Yale level stuff. Let me just bang this out really quickly. That's probably what actually happened. Um,
Yeah, exactly.
that is a great story. And here's what's even crazier. And you didn't even tell me this. I just looked it up online. You had a good number on the table. You know, not bad, right? It wasn't like they were like here in Texas. They're like, go try the case. Like that, you had a multi-million-dollar um, settlement, and you decided not to take it, not because your client didn't want to. Your client was like, whatever you want to do, we'll do. But there was another story behind that, right?
Yeah, well, I mean, obviously, I consulted with my client, and
Of course, yeah,
she and I were in agreement that the offer that they had put on the table was lower than what she needed and what she deserved. Um, and we were really concerned that she wouldn't be able to be taken care of in the way she needed to be in her
okay,
life, and
yeah,
she did need and does need a lot of help. But one of the points that I wanted to make and that my client wanted to make was that there needed to be accountability here
yeah,
because she had been gaslit for years by this doctor into thinking there's nothing wrong with you. You're a little overweight. You have a vitamin D deficiency. And I think that there was a part of both of us that really wanted to hear the jury come back and speak truth to her experience
yeah,
and basically say, we believe you. We believe you. Um, this was wrong. You were wronged. And I
right,
think as lawyers, and I'm guilty of it too, you can lose sight of the importance of that in some situations. But I think it was critical for her to hear that, especially since what she'd been through.
yeah, yeah. I mean, it's sometimes you just feel like is it bad happening to me, like because I just misunderstand, what real life is, or is this actually a harm to me? And to get that justice, that accountability, that emphasis that you were right, it's huge. It's huge. Um, all right, but this wasn't your. You and I were talking off air about our first like trials, right? So this was what, your second trial,
This was my second trial where I had helped out on trials
right?
before in the background, but this is my second trial actually. Um, uh, well, that's not true. I had tried one case to completion before this. I had tried
Okay,
another case in June 2022 that settled midway through trial.
okay.
So this was my third
Going
trial,
to
my
trial, yeah.
second trial that finished.
Okay, that's fair. And you were already talking about. I don't know about you. My first trial was someone who called me on a Saturday. An attorney said, "Mike, can you go try this case?" I was like, "Well, I've only second chair cases before." He's like, just go try this one. It'll be fine. Easy. You don't have to bring in any experts, nothing like that. Affidavits are there. Just go try it. I'm like, really? Yeah, let's do it. Right. So I'm supposed to show up on Monday. So Sunday or Saturday afternoon slash Sunday, I'm like looking at the case, and the case is getting worse by the page. Client lied all the way through his deposition. This happened during this crazy hurricane. There was no damage to his vehicle because he had a tow hitch. The other guy's vehicle had a little hole. Causation's really not there. He has a history of back and neck pain. Not only that, he's disabled for it, and he's saying that this collision caused his pain from the day of the collision till right now. So I'm like, okay, pre-existing. Then the client's actually not showing up for the trial. So I'm like,
Oh,
okay, well, this is gonna be fun. I ended up getting a verdict, not a very good
nice.
one, but a
It doesn't
verdict.
matter. That's
Uh,
impressive. The fact that you won that case is impressive.
and so after that, I was like, I need to actually check and see if I really want to try the case before saying yes. But you're like, hey, yeah, I want this experience. I want to keep doing this. I want to get better every single day. So yeah, let's do it. But you know, that's one thing I wanted to really talk to you about is that, as young attorneys, it's really tough for us to feel like in our own skin, ready to try cases when we're, you know, because when you're in your, early 30s, realistically, most of us haven't tried 50, 60 plus cases. that was the norm for the people who are in the ranks now, in their 60s. But for us, that's not happening. So what mentality are you using to say, I'm going to push this? For example, that one personally, that would, if I'm on my own, that would kind of terrify me, right? So I would still try. I would probably do a lot of the same things you did, push that stuff. But when it came to that multi-million-dollar verdict, or sorry, settlement on the table, I had to have a real discussion with myself. I'm going to go try this case. So, what mentality do you use to kind of get over that, and what can you tell young attorneys to use?
It's such a good question and such an important topic because I
Yeah,
think as young lawyers, and I don't know about you, but I've been on the receiving end of that. You're in a deposition or you're in court with an older lawyer, and you get, they either directly say it to you or impliedly, like, "Oh, youngster, but I've been
yeah,
doing this thing. I've been doing this for years." That whole mentality, and it's like, well, yeah, that you can do something like pretty poorly for a long time. So
yeah,
I think there's like that, you know, there's that stigma against younger lawyers, but um, I can remember probably 2 years before this verdict being in the thick of a couple big medical malpractice cases that settled for one settled for 8 figures and another close to 8 figures,
yeah,
where I was on the other side from this older lawyer, well regarded, really experienced med mal defense lawyer who was chirping in my ear for years, like how I didn't know what I was doing, I didn't know what I was talking about. You're just off the rails, and he really got in my head. Like I was really insecure
right,
about it, and like I feel like I'm right, and like I feel like the case is going so well when I would take depositions, but like he keeps talking to me like like an idiot. And at the end of the day, like when the smoke cleared and the depositions were taken and the expert reports were produced, and he had to obviously go show all the evidence to some insurance adjuster
right,
or purse puller, and they realized, holy crap, we've got a problem, and they settled for a lot of money. I think that was a really important transitional point for me in my career, to where I was not that I didn't not that I became like, oh, I'm invincible, because I don't
right,
ever feel that way, but like, oh, I'm not crazy. I was on the right track. I was scoring points there,
yeah,
and it allowed me to feel more comfortable in my own skin. And so, to answer your question, when in September 2022, when that offer was on the table, I think I was more able to decline it and really feel comfortable in my own skin, which I think is one of the biggest um, things about being in a courtroom, is to be able to be yourself.
yeah,
Not that you don't pick things up from other lawyers before you, but you can't be somebody else. And I think juries pick up on that type of thing.
yeah. So, people ask me about, how do you take, for example, what Keith Mitnick talks about, or you know, um, uh, I don't know. There's so many people like David Ball, all this, and like, and mix it in with you, and like, are you just following their guides, and are you just following their? No, I'm not. What I'm doing is I'm putting a spin that's authentic to me, right, at all times. If like, I used to work when I first came out of law school at a plaintiff firm that they were really, really aggressive and in an uncomfortable manner, where like they just want to nitpick and bother the other side on every little thing. Okay, I'm not like that. Okay, I want to I want the truth of the trial to be the truth, and like push it that way, and be cordial with defense counsel about certain things to get this moving. Um, but I I know myself that when I'm in trial and I'm doing certain things of evidence, I show that aggression because I'm a big dude. Showing a little aggression kind of is like, people are like, "Oh, I need to pay attention," right? And then I come back to myself just because it escalates. You're trying to build that. You're trying to get the jury to understand where you're at in certain situations. So, um, authenticity, huge. It is huge, and I think a lot of it is, you're right. Like, you've got to realize that no one knows what they're doing. We're all trying to figure it out. So your plan is probably, it's better because it's your plan. It's what you want to follow. But you have the best, the better guess of anyone else, or the worst. The only way to find out is to keep trucking away and trying to figure it out. So, um, I have had that youngster talk before plenty of times. The youngster talk for me is more like, Well, you're just yeah, you're Mike. You're too young to remember whenever we used to have the courtroom and blah blah blah. And that's his way of saying, "I've tried so many cases, done anything. You sure you
Right,
don't want to
right,
settle this, right?"
right, right.
And I'm like, "Hey, man, I think you're too old to realize that your microphone's off. Maybe you should just click that."
Click unmute. Click
And
unmute.
this grainy video comes, the thing is down. It's not even looking at it. You're like, dude, I need to just look at like your belt the whole time. Can we like figure this out? So there's a lot of pros and cons, right? I think I'll be honest with you. Trial experience aside, there's a lot more you and I are going to learn. But I think now is the time for us that we're going to be the next, covers on it, especially you, man. I mean, that's a huge verdict. I mean, congratulations. That's
Oh,
huge
thanks, man. I
on,
appreciate
on
it.
a diagnosis case like that. I would never touch that case, especially here. Never do it. I'd be like, look, I'm so sorry. Nothing I can do. But for you to, not only do it, but say no to a multi-million-dollar settlement and go out and try it and get a great, great verdict for your client, that's huge. But are you using more like visuals than you think than other older attorneys?
Well, it's ironic, and now I'm going to sound like I'm contradicting myself, but one of the things I love to use in a courtroom is an easel with a good old fashioned Sharpie,
Yeah, keep it
which
simple.
is really like old man type of thing to do. And my
Yeah.
paralegal Courtney makes fun of me for it, but I love the real time interactive component of when I'm trying to make a point on cross exam, I drag the easel out
Yeah.
and I'm writing, the word I want in red as
Yeah.
it comes out of the expert's mouth, whether that's neurological weakness.
Right.
And I don't think there's a right or wrong to it, but that
No.
just feels comfortable to me because I like the squeak of the marker and I think people are like, oh, he's right. Someone's writing something. It must be important.
Yeah.
And
They're present, and that's
yeah,
important.
they're
That's very
present.
important.
It's interactive. You're bringing them into the action, I think. And Mark Lanier, who I assume you know of Mark, just not only because you're in Texas, but because he's probably the best trial lawyer in the world. But
Yeah, because
um,
he's Mark
I,
Lanier.
yeah, yeah. But and I know Mark, and I got a chance to hear him speak in Miami recently, and um, this was after my verdict, so I didn't even know he did this. But he was talking about using a Sharpie, and he
Yeah.
said that he'll you know write as the defense expert saying something that he's gonna contend with on cross.
Yeah.
He's squeaking it out with a Sharpie um, as the guy's saying it or the gal's
Yeah.
saying it, so the jury hears and sees that, and then he goes and makes that point on cross and beats that point down. And he said it's almost like Pavlov's dog because by the third week of trial, once the jury sees Lanier pull out the marker and squeak it around, they before he's even crossed the defense expert, they're saying, "Well, that point's not going to make sense."
That's
He's
mute. I
gonna
mean,
so
they're all just looking at the defense expert, just like he doesn't
yeah,
like it, and I if
exactly.
he doesn't like it, I don't like it. No, so actually here in Houston they do the Linear Trial Academy, and I went like maybe 2 years ago. Fantastic. He
Nice,
tells you what pens to get, how to do stuff. The next day I had a trial and I changed everything, or sorry, that Monday I had a trial. I changed everything for that trial and got his IPVO. The only thing I'll say is I don't know how to draw very well, like at all. And so like he shows like his illustrations that he does, and I'm like, that's never going to be me. That's just not going to happen. I can do maybe a stick figure, and it's not very good. Um,
right?
but you're right, and the thought process for him, I understand it, is not only are you making something visual, right? So people see on just like you're doing with the easel, writing, but you are also making them present because you are doing something in front of them as everything's going live. And that's the one thing I'll say with like PowerPoints and stuff that does sometimes take away from, right? Because I mean, how many times have you been in a meeting or something like that and a PowerPoint goes on and your eyes go to the back of your head, especially if the PowerPoint is like gray and
Exactly.
black?
And
Yeah.
maybe that's just because I skipped too many classes in college, but I have that same I have that same response to PowerPoints. Like when a PowerPoint comes on for me, it's like time to tune out. That's just me.
Yeah.
But one thing, just to say one quick thing about the easel,
Yeah.
that I think helped was like, you know, throughout in this last trial, through the mouth of the defendant doctor himself, I adduced from him all the symptoms that she had when she was seeing him that he agreed were consistent with a potential spinal cord injury or mass. And so
Yeah.
not only did the easel become a way of me writing, but it became sort of this evolving piece of evidence in the case because, as I'm cross examining him, and I spent a ton of time with him. I mean, I crossed him for like over a span of 2 days. I'm
Yeah.
dragging the easel out and I'm writing, you know, can we put that as number 10, doctor? That
Yeah.
the numbness in the feet. And then I was able to, and each time you bring that easel out, then they're seeing just the laundry list of symptoms that the
Yeah.
doctor himself has already said are consistent with her injury. So I think that was good too. But I've seen so many lawyers do awesome stuff with technology too, and like
Yeah.
trial technology and imagery. I think there's a lot of things you can do these days.
And I think a lot of it's on the plaintiff side, right? Because our goal is to get the largest outcome for our clients in the most compelling way. So I think a lot of it comes from us. So it's really interesting when you're talking about the easel. What I'm picturing is kind of like a Venn diagram, and like on one side is the stuff that's like, oh, this wouldn't be her symptoms for this, and the other side is absolutely out of the world, and in the middle is these are things that you absolutely like. If these are present, you need to do X, right? And your laundry list is going so long that it's like this isn't a Venn diagram anymore. You need to do this, right? And so that's it's genius. I mean, it really is to do it that way, because at the end of it, you're just like, I need more paper. I don't know, doctor. I don't know what you were doing here.
Well, this doctor, he didn't do himself any favors because he changed his testimony a lot, and I had to impeach him a lot, and not only impeach him, but I got to pull out the easel a couple times and say, "Well, doctor, I mean, yesterday didn't you tell us?" And I like to say, "Didn't you tell us?" Like
Right.
not the
Because you're
jury,
with
but
the
like
jury.
us.
Yeah.
Yeah, like I'm
Yeah.
like and it's like didn't you tell us that uh the L5 tingling was in fact consistent with the spinal cord injury? And
Yeah.
I'm pointing to the stinking easel where I wrote it, and everybody in the courtroom remembers when I wrote it yesterday. And then so it's like, oh well, yeah, and he couldn't get out of his own way, which was
I
I
mean,
think was a factor in the size of the verdict probably.
I think halfway through, you should have just started taking the easel papers, folding them up, and being like, "Didn't you say?" And just having it in like a present, open it up, and be like, mm. Just like, what are you doing, man?
Well, I do
Um,
think once or twice I think I did actually go to get the easel, and he went back and was like, "Oh no, yeah, you're right." I think by the end he
Please don't go back there.
he finally was like, "I'll tell the truth" or whatever.
That's smart. And the the us technique, it's I think from 12 Jurors, One Voice, Carl Bellinger, I think, talks a lot about that, and it's very, very helpful. So, man, good on you. Seriously.
Thanks, man.
So,
I appreciate it.
what do you, if you could give a young attorney first, year, 2 years, what advice would you give them?
Um, Geez, I would just say get in the courtroom and watch as many trial lawyers as you can who you look up to and who you idolize, or people that have a reputation for doing well in trial.
Yeah.
But also don't lose sight of yourself and
Yeah.
be yourself. So pick up those things that great lawyers do well, but don't compromise your own identity, and be yourself.
Oh, 100%. 100%. And if someone wants to get in contact with you, whether it's to refer you a case or, to even talk to you about any sort of medical malpractice case, how would they get in contact with you?
Well, if you're under the age of 30, I have a TikTok. and
Well, hold on.
which
I'm
well,
31. I'm a TikTok. Come
actually,
on.
some of my TikTok followers are like 60, but I'm Tommy the lawyer on TikTok, and I somehow accumulated like 200,000 followers.
What?
Don't ask me how. I did a video that went viral in August, because my wife told me to do it. But anyways, that
What was it?
uh,
Hold on, no, no, no.
it was
Not
like just
anyways. What was it?
it was just some like silly, medical malpractice. Like, I'm a medical malpractice lawyer, and this is, I forget what it was, but it was some
Yeah.
informational thing that I'm like, I'm gonna put people to sleep. But then for some reason, people were watching it. So, but that's TikTok. But I have my email, which is tom@tombosworthlaw.com.
Okay.
Um, so that's the best way to reach me.
So if they have a medical malpractice case, they should email you, not just send you a DM on TikTok. I just want to make sure.
Either way,
No, it's
I read them
actually
all.
I did a thing on branding for the viewers like the last couple months. So I had John Morgan on, Morgan, and we talked about kind of the old style branding and how he's doing it and how it's evolving and what he's doing. And then I had Mariah Solis on, who she's really big on TikTok, and she had one that had like, I think she told me at the time like 1 million views, and she's like, I didn't say a word. It was almost 30 seconds. She's a products liability attorney. She just pointed to the car she would not buy, 1 million views, and people
I
are commenting on it.
I did a video, it was like the three products I'll never buy, and
Yeah.
I'm wearing a T-shirt. It's like, and it gets 5.6 million views, and I'm like, why are secretly why are this many people watching this? This is such a silly video. Who am I? I'm just some lawyer. Like, I wouldn't buy these products. So what?
Yeah.
But yeah,
That's
no,
hilarious.
it's a wild time. I think the legal field's in an evolutionary phase in terms of marketing and advertising. I think we're
100%.
kind of at the apex of it right now, in my opinion.
Yeah, it's really interesting. So it's kind of a leveling playing field, but also not, because you've got to put in good money to actually really make something big. But I mean, if you've got kind of a followership already, you can really build that to really get clientele and get people who know you as a name. So, it's either or, but I will say it's kind of leveled things more, right? Before that, before TikTok and before Instagram was really advertising worthy, right? It was more just photos of your friends, and you're like, okay, that's cool.
Yeah.
you know, Good job, Michelle. I'm glad you went to Italy for the fifth time. Cool, like whatever, right? But now it's everybody's doing the influencing. You can't scroll without getting an ad for more than 10 seconds, right? It's really kind of leveled things a little bit more because you can kind of build your brand through that, right? And what do most people do? Most people say, "Oh, I know, Attorney Tom or Attorney Mike," right? Oh, cool. Do they go immediately to the website? They might, but for most people are already on Instagram. They're like, hmm, and they get it and they see it and they see what they're looking at, right? And then they automatically know, is this the person I want to go with or not? So, yeah, no, 100% agree. I think it's definitely changing. It is definitely changing. So, Mariah, she says she gets like 99% of her cases through social media. That is 10 years ago. Nah, no way. Right.
Well, I
So,
think, and this is just my opinion, doesn't mean anything, but I think people, especially younger people, they are not watching TV at midnight when these commercials come on. 1-800, no, and I'm no look, no, not coming at those lawyers. There's lawyers doing that are
doing
wildly
well.
successful. Yeah,
Right.
I'm
Yeah.
just saying, I think the tide's changing, and I think people crave and expect a more authentic connection,
Yeah.
even if it's a lawyer, even if it's a doctor, even if it's a professional, where you used to go to the yellow pages or Google. Now people are like, no, I want to hear you talk. Like, I want to see you and
Yeah. See
see
what
if
you're
there's
about.
some, yeah,
Yeah. 100% agree with you. And I also think that there's different modes now. Like a lot, kids younger than us are looking at YouTube, right? And for example, we don't, in my household, we don't have cable anymore. We have Hulu TV, which is basically cable, right? But it's not, in that I can watch anything at any time and I can just maybe watch an ad to do it. That's fine. And Hulu actually gives just not big corporations ads, but, you know, law firms, that it's actually not unaffordable, right? You still have to have a marketing budget, but it's affordable. So I'm saying all that to say that it's just a different mode now. You've got to kind of build that. But I agree with you. People are not watching it and wanting to watch that commercial. If you're going to do it, be personal, be interesting within that time period, and do it on different modes. So whatever it may be, and have a real social media following. So I'm learning a lot about it. I had another attorney on here talk about branding by itself. It's super interesting. It gets you to really understand who you are, and it's either really, really enlightening or really, really terrible, and or a mix of the two. So, but anyways, man, look, it wasn't about that. It's just always nice to talk to someone around my age who's killing it, and kind of see what they're thinking about. Also, someone who has like that many followers as a medical malpractice attorney. That's crazy.
Yeah, it's I didn't see it coming, but I really appreciate being on the show, and I'm glad that
Yeah,
you asked me to talk.
absolutely. Thank you so much.
All right, thanks, man.